My name is David Scher, and I'm a partner at Block, O'Toole and Murphy. One of the types of cases we handle are motor vehicle accidents that involve rideshare vehicles. We're talking about Uber and Lyft, services that all of us are using more and more and more in our everyday lives, not only in New York, but all throughout the country. If you're involved in a motor vehicle accident that involves a rideshare app, where you called for an Uber or you called for a Lyft and you get in the vehicle, there's some things that are important to know. First of all, whether you are aware or not, and most of us frankly are not aware, when we agree to the terms of service for a company like Uber, among the many things that we're agreeing to is binding arbitration in the event of a claim for injury. Now, that's very important. What it means is that if you call for an Uber and you get in and you're involved in an accident and you want to bring a claim for your injuries against the Uber driver, Uber has an opportunity to say, you're not allowed to bring this case in court. You're not allowed to file a normal complaint in the Supreme Court of New York because, check your agreement, that big click wrap when you scroll to the bottom and hit OK, you said that we can go to arbitration. So that's what we're going to do. This case is going to go to arbitration instead of court. Arbitration tends to be a forum that favors defendants and not plaintiffs. It tends to be a forum where plaintiffs end up with less of an opportunity to voice their case and lower awards. So when you talk to a lawyer, if you've been involved in a rideshare accident, ask the lawyer, is this case going to be able to be brought in court or not? If it goes to arbitration, what does that mean for me and for my case? One of the things that's important to us as lawyers when we're representing a victim of a car accident that involves a rideshare vehicle is we know that there's a greater than normal opportunity to obtain information about the rideshare driver and the trips that he or she has taken. These apps like Uber and Lyft, keep track of practically everything. So for example, if you've been involved in an accident with an Uber or a Lyft vehicle, we know to a certainty that we're going to be able to find out what that driver had been up to in the hour preceding the accident, the 8 hours preceding the accident, the 24 hours preceding the accident. So perhaps we can uncover that that driver was driving for too long and was overtired, or that that driver was speeding based on the locations we know that he or she was at, based on the folks that he picked up and dropped off. So you can really chart out the driver's day or night, and that can often lead to evidence that helps us prove that the driver was negligent. Sometimes the evidence that we're able to obtain from rideshare apps and from all of the data and metadata that can be demanded is we can actually determine that the rideshare company itself was negligent. For example, we may be able to determine that Uber should have known that the driver in question had been driving 24-hour shifts over and over again, which is careless, is negligent, leads to drivers being tired and inattentive and getting in accidents. And in that case, we may be able to prove that Uber had notice of this condition and that condition led to the accident. Whenever there's a ride share involved in a motor vehicle case, we at Block, O'Toole and Murphy craft very specific discovery demands directed to obtain data and information that we know exists on these platforms, information that can prove critical in order to establish your case and get you the compensation you deserve. We'll navigate the case through court and to trial if we can. We'll navigate the court to arbitration if we can. Whatever forum we have to be in, we will take the case on and get you the best result possible.